And
That's
true.
Kathleen, too.
Right. All right, guys. Ready, right? The House Elections Committee will come to order. Would the clerk please take the attendance?
Chair Cerniglos.
Here.
Representatives Wagella.
Here.
Cope.
Here.
Colazar.
Here.
Burns.
Here.
Churches.
Present.
Smith.
Present.
DeBoyer.
Here.
Madam Chair, you have a quorum.
Thank you. Representative Churches makes a motion to adopt the minutes from the May 21, 2024 meeting. Without objections, the minutes are adopted. For today's agenda, we will hear testimony on House Bills 5571 through 5576. If anyone wishes to testify today, please submit a card and mark that you wish to speak. We will now go at ease. The committee will now go at ease at the call of the chair.
The Elections Committee will come back to order. We now will have testimony from Chair Cerniglos on House Bills 5571 and 55 through 5576. She is joined at the stand by Erica Parisman from Promote the Vote, and hopefully I said that right. And Melanie Mason.
Thank you, Chair Wagella and committee members. The legislation that we are discussing today was initially brought to us as formal recommendations from the Board of State Canvassers. As you may remember from their presentation a few months back, the Board of State Canvassers convened a work group last year made up of bipartisan election lawyers and experts who work together to closely examine the current practices and processes that take place regarding petitions here in Michigan. More specifically, the group wanted to examine whether they felt like there needed to be updates and or changes to the Michigan election law to better improve and streamline the petition process. The findings from this bipartisan work group led to several suggested updates and changes to the Michigan election law. The main goal with these bills is to codify current practices of the Board of State Canvassers while also ensuring that Michigan election law is clear as to the requirements for the petition process. The bills also address ways to ease recent increased burdens on the Bureau of Elections. As turnout has increased in the last two gubernatorial elections, the minimum number of signatures required to be submitted also increases, as the minimum is set by Michigan's Constitution. This has led to an increased burden on the Bureau as the timeframes to process this increased volume have remained the same. An additional burden was seen in 2022 when more than 70,000 fraudulent signatures were submitted, and neither the Bureau of Elections nor the Board of State Canvassers had a procedure in place on how to process this unprecedented situation. The procedure utilized by the Bureau was ultimately upheld by the Michigan Supreme Court, and thus we would like to codify this process. Since the time of introduction, I have had several conversations with election experts and other stakeholders, and we decided that while we are making changes to these sections of the law, it would make sense to take a holistic approach and see if there were other pieces of the petition process that we could improve. These conversations ultimately resulted in several substitutes which seek to bring clarification to the petition process by updating confusing terms or references, as well as requiring the Bureau of Elections to review the petitions in the order in which they are received, and codifying other current practices, like making copies of petitions available to petitioners and challengers for a reasonable fee, amongst several other changes. We have representatives from Promote the Vote sitting with me today to speak more on these substitutes in greater detail. Before getting into the details of the substitutes, I want to highlight what the bills as introduced set out to do. Aside from some clerical changes, the bills will do the following. As introduced, the bills moved back the filing deadline and required that initiative petitions would be submitted 200 days prior to the November election, and constitutional amendments would be due 160 days prior to the November election. This has since been changed back by the substitute, so taken out and put back to where it was before. We are continuing to have conversations as to whether we want to change that timeline. If we do pursue changing it, we would want to increase the number of days that that individuals could actually collect those signatures. So we want to make it, fair for groups to be able to get their petitions on the ballot, but we also want to take into consideration how much time it takes to process. So that is not being changed at this time, but conversations are continuing, and we welcome input from interested groups. So these bills make clear that the Board of State Canvassers is authorized to use statistical random sampling in canvassing petitions, which is the current practice. It clarifies authority for the board to disqualify obviously fraudulent petition signatures and to have fraudulent signatures referred to the Attorney General for investigation. It includes the qualified voter file in the necessary records that clerks must check doubtful signatures against. It removes outdated references regarding how the Secretary of State must communicate with the Board of State Canvassers and how they must announce that the Board of State Canvassers has declared a petition as sufficient. Removing language that required an individual to sign a sworn affidavit if they are a paid signature gatherer, and requires that the petitioner must state in writing that they made a good faith effort to sort signatures and that they are submitting at least the minimum number of required signatures. So that is kind of an overview of the original bills as introduced, which were based on recommendations from our Board of State Canvassers and the Secretary of State's office. And now, turning to the substitutes, I'm going to turn it over to our representatives from Promote the Vote to explain more on some of the additional changes that we are considering.
Well, thank you, Chair Cerniglu and Vice Chair Wagela, and members of the committee for the opportunity to testify today. My name is Melanie Macy. I'm Policy Counsel at Promote the Vote, a nonpartisan coalition dedicated to preserving and protecting voting rights here in Michigan. I'm joined today by Promote the Vote Senior Advisor Erica Pearsman in support of the petition bill package in front of the committee today. So our concern at Promote the Vote is focused more on the ballot initiatives, the rights that are secured to Michigan voters in the Michigan Constitution, to petition for a constitutional amendment, a new law, or a referendum on the existing law. So our testimony will focus on the bills making changes to the election code for the ballot initiatives, which is mostly 5571, 5573, 5574, and 5575, and specifically the substitutes versions of those bills. So we'll kind of walk through those. The package of bills, as originally introduced, as Representative Cerniglu has said, did some really important work to make the petition process smoother in several key ways. So codifying the statistical random sampling for the signature canvass and allowing for substantial compliance with petition form are some significant steps that really ease the burden for the Board of State Canvassers, the Department of State, and really the petitioners. And as you heard in the Board of State Canvassers presentation a few months back, they are unanimously in favor of those changes, and Promote the Vote is also in full support of those two changes. But the substitute bills that are presented today really add up to an extensive review of the petition process, as Representative Cerniglu said, and it moves beyond what the bills that were initially introduced, which makes sense because once legislators had cracked open the section of the code, it really made sense to kind of take a holistic look at what the petition process is, and we believe that the resulting changes will be a huge improvement for all of the parties. So when we step back and take a look at what's happening in these bills, and there's a lot happening in these bills, the overall theme is really to simplify. Our current law regarding petitions is pretty complicated, needlessly complicated, but at the same time it leaves some holes. It doesn't address everything that the sponsor of a ballot proposal or an initiated law would need to know. So the amendments here propose both simplify the existing provisions, but also fill in the gaps where information is missing or where the process isn't clear in the law. So starting with House Bill 5571, it's sort of a focal point for many of the changes that will bring that greater clarity. It does include 2 new sections, one that brings together language on the petition summary, and another one that really carefully defines the terms alter or abrogate, which have been debated in the past, as those terms relate to constitutional provisions that would be impacted by a proposed constitutional amendment. So the definitions that are in the bill are codifying existing case law, so it's just taking them out of pretty much directly from case law into the statute. In addition, the 5571 does a crisp new take on the petition form itself with kind of a revamp of Section 482. As the Board of State Canvassers is moving from that strict compliance standard to the substantial compliance standard, it makes sense to have the form be more streamlined with fewer of those kind of gotcha type rules, just to ensure that the will of Michigan voters isn't subverted by technicalities. So we support the idea that voters should be presented with clear, easy to read and understand petition forms, and that sponsors of ballot proposals and initiatives shouldn't be forced to argue endlessly about font size or the minutia of how things are placed. In 5573, the focus is on the Board of State Canvassers and the Department of State as it relates to their responsibilities and transparency, primarily regarding the actual canvass process and then the determination of petition sufficiency and insufficiency. So it covers how the process works from the beginning, when there's an initial submission of the petition form for review, all the way to the end to the determination of sufficiency or insufficiency. And then, as inevitably occurs, it also handles how aggrieved parties can seek judicial relief. So the bill outlines the signature review process by the Bureau of Elections staff and clarifies that staff has to begin reviewing the signatures in the petitions in the order that they're received, mandates regular online status reports during this review, and then sets out a timeline for the challenges and any rebuttals to those challenges during that process. Then in 5574, it's mostly updates to outdated languages and some provisions of the code that were just obscuring the kind of how the petition process should work for Michigan voters themselves. So those changes are really centered around making it easier for Michigan voters to follow what's happening in the petition process, which can be complicated. So that includes changing the numbering system to include the 4-digit year instead of the 2-digit year, adding a special designation for ballot questions that appear on a special or primary election. And it tightens up the Secretary of State's duties regarding when they make information and what information they make public when the petitions are first submitted for review and then when they're filed with the signatures included. And it also clarifies how the ballot question itself should be worded so as to not be confusing to Michigan voters and how that language will then be distributed to polling places. And then finally in 5575, the change, as Representative Cerniglu mentioned, from the originally introduced bill brings the deadlines for petition filings back to what they are currently. And Promote the Vote supports keeping these deadlines pretty close to where they are, but as was mentioned, we recognize that the Department of State has some concerns with how the steps fit together in the process. And so we would have concerns about the timeline as introduced if there were no changes as well to the signature gathering window, as the representative mentioned. Because a timeline squeeze like that would really be unfavorable to Michigan voters who are trying to exercise their constitutional rights. And it would make signature gathering and the petition planning process a lot more difficult. Right now, as it stands, our 6-month signature gathering window is one of the shortest nationwide. And it's known that gathering signatures is easier in the warmer weather, so petitions shouldn't be punished because Michigan winters can be long. So viewed together, these bills are really cutting through some outdated bureaucratic language and the processes to really clarify, organize, and simplify Michigan's petition process. We urge the committee to report them favorably, and we're happy to answer questions.
Representative Smith.
Thank you, Mr. Chair, and thank you for being here to testify. Initially, it was the Board of Canvassers that were wanting these changes done, and as you stated, there are a lot of things that are happening in these bills. So since you've come in and taken a look at these, have you gone back to the State Board of Canvassers and asked, are they supportive of these changes that you are proposing? Have they been part of that?
So that sounds like it's maybe for you.
You might know. So unless you know something I don't. I think we might defer that question when we have the Secretary of Department of State come up, because I know they act as more of a liaison to Erin Shores, indicating that she will answer that when she comes up.
Okay,
Yeah.
thanks.
The Department of State has been part of the conversation.
Are there any other questions? Seeing none, we will go at ease.
Thank you. All right, the committee will come back to order. We will now, let's see, actually, we will now have testimony from Erin Shore from the Department of State. Actually, I don't know that we'll have testimony, but she is available to answer questions. And we did have a question from Representative Smet, if you want to repeat your question.
Thank you, Madam Chair. And hi, Erin. Yeah, I'm just curious. I'm just if you guys have gone back with all these proposed changes and subs to this Board of Canvassers and requested, do they support this? Is this part of what they are wanting to see as well?
We've taken the drafts back. We haven't had a chance for the board to have that discussion yet and give a firm opinion, but our staff that routinely works with the Board of Canvassers was part of all the discussions, so we believe this is in keeping with their prior conversations, but we are waiting on that formal sign-off still. And I'll let you know what they say one way or the other.
One more quick question. Do we expect that they may come back and support the changes that are before us as well, or is it just going to come from your department?
That's up to you. We can certainly ask them to come back, or at least some of them as they're able. As you know, I'm sure they've been in a couple of meetings in the past week. This is a busy time for them, but I know these changes are important as well. So.
I mean, at the very least, we could have them write a letter.
Absolutely. If they do take a formal position, the last time when they've discussed it, it's been in their public meetings. I'm not sure with their meeting schedule exactly how that process will work this time.
Okay.
But
thank you.
we will try to make them as available to you as you would like them to be.
Thank you. Representative DeBoyer.
Thank you, Chair. How are you, Erin?
Good. How are you?
Good. Just really quick, help me understand the substantial compliance modification. So I guess the root, the base of that question to you is really in this aspect. Is substantial compliance only going to be applied to the format of the petition? Or could substantial compliance be applied to the actual act of collecting signatures?
My understanding is that substantial compliance is limited to the actual form of the petition itself. And that was one of the pieces, even with the bills that were introduced, where the board still had more questions about how that would apply and how they would need to interpret whether something was in substantial compliance, because strict compliance is easy, at least to have a bright line. Substantial compliance requires an element of being able to determine whether something is not exact but still is understandable to the voter. But the requirements in terms of how many signatures you have to have, I mean, that's set by the Constitution. That's not something they can make substantial.
I did recognize there was one piece in one of the bills that talked about the signature perhaps not having an address or a street name or something like that, but yet it could be deemed to be an appropriate signature if it was able to be discovered that in the qualified voter file that the individual was indeed Bob Smith, right? The name we always use. But you don't see that that's a substantial compliance issue potentially? Meaning, are we going to accept signatures or accept circulator signatures if we determine that it's substantially complying. And the worry that I would have is if we're going to accept something as a substantial compliance on this petition, have we set a precedent going forward that forever we will accept that? So then we are drawing a bright line, right? So.
And my understanding is there have been elements in the past that are a bright line. The way the county box was pulled out separately, that had to be correct, and we had to toss an entire signature if it was not. And so we're looking at changing that. Okay. But there has already been some ability to do as you say. So if I wrote EL instead of writing out East Lansing, we already have some ability to say we can find the voter. There's not a question. If it's Aaron Shore, I think I might very well be the only Aaron Shore in the Michigan qualified voter file. So as long as the signature matches enough, that would be fine. If it's Bob Smith, he's going to have to include more information for us.
Right. Okay. Thank you.
Thank you.
I don't see any further questions, so thank you, Ms. Shore.
Thank you.
Now I'm going to read off a couple cards here. We have Kim Murphy-Kovalik from Voters Not Politicians in support of the bills. Looks like all of them not wishing to speak. We also have Sherry Ritchie from Michigan Fair Elections, Pure Integrity Michigan Elections, Stand Up Michigan, the Freedom Alliance, Mid-Michigan Women for Conservative Values. And Ms. Ritchie opposes the bills, again, all of them, and does not wish to speak. There being no further business before the committee will stand adjourned. Thank you.